March 6, 1857. The basement of the United States Capitol. An 80-year-old Chief Justice, Roger Brooke Taney, rises from his chair, so frail his voice barely carries past the first row of spectators. He begins to read. In the chamber, 9 justices. On the docket, 1 enslaved man, Dred Scott. But the question Taney is about to answer reaches far beyond a single freedom suit. It will decide whether 4 million Black Americans can ever be citizens of the Republic, and whether Congress has the power to stop the spread of slavery. Dred Scott was born enslaved in Virginia around 1795. In 1833, he was sold to Dr. John Emerson, an Army surgeon who took him to Fort Armstrong, Illinois, free soil under the Northwest Ordinance, and later to Fort Snelling in the Wisconsin Territory, where the Missouri Compromise prohibited slavery. At Fort Snelling, Scott married Harriet Robinson. 2 daughters followed, both born on free land. Emerson died in 1843. Scott offered $300 to buy his family's freedom. Emerson's widow refused. So in 1846, the Scotts sued in the St. Louis Circuit Court under Missouri's once free, always free doctrine. A jury freed them in 1850, but in 1852, the Missouri Supreme Court reversed, declaring, with breathtaking frankness, times now are not as they once were. The case now entered the federal courts because Irene Emerson's brother, John Sandford of New York, claimed ownership. The Scotts could invoke diversity jurisdiction, citizen of one state suing a citizen of another. Their case reached the United States Supreme Court in 1856. But behind the scenes, the incoming president was intervening. In February 1857, President-elect James Buchanan wrote to Justice John Catron, his friend and a Tennessean on the court. Buchanan wanted to know how the court would rule, so he could tailor his inaugural address. Catron revealed the majority would strike down the Missouri Compromise, but they needed a Northern justice to join to give the ruling a national, not merely Southern, imprimatur. Buchanan wrote directly to Justice Robert Grier of Pennsylvania, urging him to join the majority. Grier agreed. On March 4, 1857, at his inauguration, Buchanan announced the slavery question was about to be speedily and finally settled, and that all good citizens should cheerfully submit. He already knew the outcome. Chief Justice Taney took the pen, composing what he believed would be the definitive judicial settlement of the slavery controversy. He would answer 2 questions, and both answers would detonate across the Republic. First, could a Black person, enslaved or free, ever be a citizen of the United States, entitled to sue in federal court? Taney consulted the founding era and answered with categorical finality. No, Black Americans were never part of the political community formed by the Constitution. They were, he wrote, a subordinate and inferior class of beings who possessed, and here the phrase would sear itself into the American conscience, no rights which the white man was bound to respect. Second, did Congress have the power to prohibit slavery in the federal territories? This struck at the heart of the Missouri Compromise. If Congress lacked that authority, then the Republican Party, founded on stopping slavery's expansion, had no constitutional leg to stand on. On March 6, 1857, Taney delivered the majority opinion, 2 hours, his frail voice thinning as the words accumulated. 7 justices concurred. Dred Scott was not a citizen. He had no right to sue. The case should never have been heard. But Taney did not stop there. The Missouri Compromise, he declared, was unconstitutional. Slaves were property, and the Fifth Amendment protected property from seizure without due process. To ban slavery in a territory was to deprive a slaveholder of his lawful possessions. Congress had no more power to prohibit slavery, he wrote, than to prohibit the ownership of livestock. With one sweeping opinion, Taney excluded an entire race from the constitutional community. and twisted the Bill of Rights into a shield for slavery. 2 justices dissented, John McLean and Benjamin Robbins Curtis. Curtis, in a meticulous rebuttal, demonstrated that free black men had voted in several states at the founding, proof they were indeed part of the people. Disgusted by the politicization, he resigned from the court soon after. Dred Scott was remanded to slavery, but his case was now a national detonation. Taney believed he had settled the slavery question forever. He had made compromise impossible and war all but certain. The North erupted in fury. The Republican Party, told its core platform was unconstitutional, did not collapse. It swelled. Anti-slavery Democrats, former Whigs, Free Soilers, and abolitionists united around one conviction. The Supreme Court was now an instrument of the slave power. Abraham Lincoln was galvanized. His 1858 Senate campaign against Stephen Douglas produced the Lincoln-Douglas debates, and the question that would not let go: if the Constitution guaranteed slaveholders the right to bring their property anywhere, could any territory truly exclude slavery? Douglas's evasive Freeport doctrine won him the Senate, but destroyed him in the South, fracturing the Democratic Party. In 1860, Lincoln won the presidency with 40% of the vote. South Carolina seceded on December 20th. The Civil War, 4 years, over 600,000 dead, had begun. Dred Scott was freed in May 1857. He took a job as a porter in St. Louis and lived as a free man for 16 months before tuberculosis claimed him. He never saw the war or the 13th and 14th Amendments that overturned Taney's ruling, declaring all persons born in the United States to be citizens. The Dred Scott decision is widely regarded as the nadir of American jurisprudence, not merely for its racism, but because it was judicial overreach of the highest order. Taney intended to resolve a political crisis by judicial decree, and instead shattered the last fragile restraints of sectional compromise. The decision hollowed out the court's moral authority for a generation and proved that judges, no less than politicians, can bend the law to serve an ideology. It took a civil war, the blood of hundreds of thousands, and 2 constitutional amendments to undo what one Chief Justice set in motion on a single morning in March 1857. If you believe that history is shaped as much in courtrooms as on battlefields, subscribe and leave a comment below.